kind of start here. It's a little bit about this picture of myself. Hopefully you can see me. My share video should be on. I am an estate administration attorney with Cope and Barger. I deal primarily with estate administrations, probate administrations, conservatorships, guardianships, some limited probate and estate litigation, and some limited estate planning as well. I've been working in this area for about a little over 12 years now. So yeah, it's just kind of background, some comments about myself here. Okay, today's agenda. So these are kind of the broad overview of the topics we're going to be covering today. Really excited to be here talking about these topics because I don't think they're talked about enough. And we're having more and more people schedule meetings with us when someone loses their capacity or is having diminished capacity, and whether it's they're trying to plan for it, whether they're going through it, or whether it's already happened and we're kind of in an emergency situation. I just think in general, with medical advancements, technological advancements, and just our lifespans being so much longer, this is just going to be an ongoing and ever developing area that's going to need quite a bit of more resources as far as education, finances, and so on. So these are kind of the topics, right? When health begins to diminish, obtaining legal authority, right? And that means whether through the court or whether through the documents in the estate plan that you put together. Some tips on one, I'll go through what a conservatorship is, so you have an idea of what that even looks like and entails, and then also kind of going along with that, how to avoid a conservatorship, right? And then kind of to piggyback off that, we'll go on some common concerns, and then things that our firm can do to help you navigate that process, right? The dialogue, the communication that will help you as you go through and navigate that process. There is no perfect way to navigate that process. As you know, everyone has their own particular family issues and their own players who are involved and their personalities and the whole gambit of things that go into this type of discussion. So we'll kind of just raise some things so that you're generally aware, and really just have a good, strong foundational standpoint of, okay, at least I understand what this means, what the process is, how to avoid court involvement, and so on, okay? These are all of our attorneys. As you can see, we have people with different designations: estate planning, estate administration, business and tax, estate litigation, a couple of individuals that are of counsel, right? So we span numerous attorneys with multiple specialties. And I'm sure that a lot of you know quite a few of these individuals already. This is more of a complete picture of our staff, right? We have some additional people here, some people who have left, but a lot of the paralegals are there as well, support staff, marketing, you name it. Right, just a brief overview of our offices. Like I said, I'm here located in our South Coast Metro main office in beautiful Orange County. We do have offices in quite a few other locations. Some of you may have met with other attorneys and staff at those available locations. Okay, this is kind of where we're going to begin here, right? When health begins to diminish, okay? This is, like I said, an ever-growing area of much needed, important discussion. I don't believe that there's enough webinars, enough literary information out there to really guide someone through this process. And this can be just as complex or difficult to navigate than death itself. In some instances, when someone has passed, it is actually easier to manage the estate. Yes, you do have beneficiaries and heirs who are potentially making life a little bit difficult for a trustee, but this area I think is much more complex, and clients need more information, more resources, more guidance. And that's kind of what we're going to be doing here today. Okay, some common questions, right? Who makes the medical or financial decisions, right? Who is the person that you're going to appoint to do these things? And if that person is not able to assist, right, who are the backup agents, right? Who is going to be there should your spouse not be able to make a medical decision for you, right? So on, so forth. When you execute these documents, will they be temporary or will they be long-term, right? Another question typically commonly is, when are they effective, right? If I'm doing a power of attorney, do I want it effective immediately upon signing or only immediately upon my capacity, right? There are certain times when it's easier just to make it effective immediately rather than wait to incapacity. But there's other times where you want to wait. Again, it's just going to depend on the family dynamics, of certain particulars, a certain situation, and so on. Okay, kind of along who makes the medical decisions, who talks to the doctors, who decides the critical care and emergency. We'll get into that a little bit further. Will anyone share the responsibility? Are you going to have co-agents, right? And we'll kind of go into the pros and cons of having co-agents. And then who is responsible for healthcare costs? So we'll kind of go through the mechanism for providing, where the finances should come from, right? What does cost reimbursement look like? How do we avoid coming out of our own pocket to cover for loved ones' expenses, especially when money's tight in our own financial circumstances, okay? And then when to ask for help, right? That is probably the easiest. Now, right? Yesterday it was too late. Today is too late. Tomorrow is too late. Always want to be doing this as soon as possible. When everyone still has full capacity, when everyone is still fully functioning, if it's possible, you want to do it earlier rather than later. Okay, just some general brief things to consider. As a part of this, right, honoring your loved one's wishes while seeking peace with the family is extremely difficult. So like I said, kind of goes back to the yesterday was too late, right? So let's try to do these things prudently and timely. Everyone has a busy life, so I completely understand that we can't just jump in a meeting the next day. But I would always suggest meeting with your family if they don't have an estate plan. At a minimum, if they don't have advanced healthcare directive, power of attorney, right? We want to get on that quickly so that they can still have control and still have input and actually just still have the actual legal ability to execute those documents. Legal complexities involved with a court supervised conservatorship or guardianship can feel overwhelming. We are going to go through why doing private documents, and when I refer to private documents, I mean a trust, a power of attorney, advanced healthcare directive, and some other corresponding correlated documents, right? Those are private, right? Those are done with at a private office. We don't publish them. We don't file them with the court, right? In most instances. However, if you don't do those and someone loses capacity, you're out of options. And if you need to gain control of their finances or healthcare decisions, you have to go through the conservatorship court, right? Which is done through the probate department. And that means everything is going to be filed with the court. Mostly everything will be public, available documents upon request. And I'll kind of get into the much more complex process as we kind of go through the rest of the webinar. Planning ahead can potentially negate court involvement and alleviate frustration. That is 1000% absolutely true. Now, although it's going to negate court involvement and additional frustration, as you know, when you're trying to take care of a loved one, especially with diminished capacity or diminished health, it will never negate it or alleviate it completely, right? There's always going to be some constraints, some frustration, stress, anxiety, right? And we'll kind of go through some of the traits and some of the things that we can do to lower them at least, or attempt to lower them, right? That's a major goal that we were trying to accomplish here. Okay. And then knowing the process ahead of time is very helpful. Okay. And that's kind of what we're doing here today, trying to give you some information about the process so you are aware of what to expect. Okay. Obtaining legal authority, right? How do we become their voice? How do we act on behalf of our loved one? And there's a few different ways to do that. This is kind of just some background information, right? The role of a representative, right? The person that's going to act on behalf of your loved one. A personal representative is ultimately responsible for making sure that that person is physically taken care of and makes healthcare decisions. There are numerous names for a personal representative for health and medical decisions, right? You've probably heard of an executor of a will. Sorry, that's the finance. I'm going to take a step back here. My apologies. You've heard of advanced healthcare directive, right? That's your advanced healthcare agent. You've heard of a power of attorney for healthcare. Same thing. It's an agent, right? Acting on your behalf. You've probably heard of a conservator, right? That's just the same term for an agent. Now it's just through the courts. And then also a guardian, right? Same idea. I'll get into what the difference between a conservator and guardian is, but these are all individuals who are representatives acting on behalf of another individual to make medical or healthcare decisions. Okay, then we have a financial representative, right? Similar, but this is for finances, right? Making sure accounts are properly managed, bills are paid, expenses are taken care for. If your loved one's in an assisted living or long-term memory care facility, right? How are we, this person will be the one who's making sure that those payments are being made, right? Similarly, right, you're going to have medical and health expenses. Although you have someone making the healthcare decisions, you also need someone paying for that, right? Or at least coordinating if they're receiving Medi-Cal, Medicare, Medicaid, making sure those payments are being utilized appropriately. Some common terms for a name of a financial personal representative: a trustee, right? Or a successor trustee of a trust, an executor of a will, an agent under a durable power of attorney, right? And also conservator, a guardian, right? And I'll kind of break into the different designations of what that looks like. Those are all just terms for representatives, right? Again, acting on behalf of someone else. Excuse me. Okay, so this is kind of the nuclear option, right? What happens when there are no documents in place? Okay, when there are no documents in place, you have to go file a conservatorship. Someone will come and meet with me and say, Mark, my mother, my father, my loved one is no longer able to make their medical or financial decisions, and I'm trying to access their bank accounts. I'm trying to pay their bills, and the bank is stopping me from doing so. I can't access the trust accounts. I can't access their personal accounts. I can't contact Social Security. I can't contact the IRS or the franchise tax board, right? All of those institutions are going to put up a roadblock, and they're going to say, we want to see your court paperwork, okay? And that's what a conservatorship is. It's just a process through the court to get the necessary documents to establish that you have legal authority to act on behalf of this other person, right? So some general terms here. A conservator is the court-appointed representative, right? A conservatee is the person who no longer is able or willing to manage their financial or healthcare decisions, right? There are instances where someone has capacity still, but they no longer are able or are wanting to make the decisions, right? And at that time, sometimes, they don't want to sign any documents, so you're not able to do a private, but you still have to go through the court, okay? Just general overview of the court process. When you file that conservatorship petition, the court will appoint a public defender, a public guardian, and or private counsel to represent the conservatee. All of them will conduct interviews with yourself, your family members, if the regional center is involved, if APS, Adult Protective Services, is involved, if there are any other government or institutions, they will interview them. Right? Because their job is to protect the conservatee, right? Their job is to make sure that this is actually an appropriate process to be used, okay? Just briefly in the lower right-hand corner, you see some conservator's duties: overseeing finances, establishing and monitoring the physical care, managing living arrangements, and so on, right? So this is kind of just a brief overview. A general conservatorship petition it depends on each county, anywhere from 3 to 6 months until that first hearing, right? And that's where the issue comes up. Now, not to say that the court conservatorship method is a bad thing, right? Because in my opinion, it's a good thing, because it's taking the time to make sure this person is actually, one, needs a conservatorship, and two, that we're appointing the appropriate person. But for the court to do that, it needs time, right? It needs a lot of time to be able to flesh this out. So if you need immediate authority, this is a no-no, right? This is bad news, okay? Now, there are emergency petitions you can file, but as you know, you're already going to be paying attorney's fees for this general conservatorship petition. Now you're having to pay for what we call an ex parte or emergency petition, which again just drives up attorney's fees, right? And although you may have your own opinions on attorneys, right? At least my goal, and at least Copeland Barger, we want to try to minimize those when we can. So again, this is just kind of the conservatorship process, and I'll kind of go into that a little bit further here, okay? Continuing obtaining authority, representative options. Okay, this is a breakdown. We're still within the court supervision, right? We're not talking about the private documents yet. Okay, a conservatorship in California, a conservatorship typically pertains to adults, right? Those 18 and over, while a guardianship covers minors. So in other states, a lot of states don't have the term conservatorship. They just have guardianship, and that covers everyone, minors and adult, right? Here we have a breakdown. So one's a guardianship of a minor, one's a conservatorship of the person. Guardianship, like I said, pertains to those who are under 18, wide range of decisions for the person and or the estate if the minor has finances, ends at 18 years old, marriage or emancipation. A guardianship typically comes about if, God forbid, worst case scenario, the parents pass away and the child is still a minor, or if Child Protective Services comes in, right, and we've taken away the children from the parents, and we've given custody to grandparents or an aunt, uncle, or another family member, right? A guardianship will be filed to allow that individual to get financial and healthcare rights to make decisions on behalf of that minor. Similarly, for conservatorship, kind of the same concept, right? But it's just for adults, okay? It's just for adults to make estate, financial decisions, healthcare decisions, right? However, there are certain code sections in the probate code that give you certain authority to make certain decisions. And then it ends at the person's passing or when they become able to make decisions again. Conservatorship, the court will always want to limit the powers it gives to the conservator, right? It wants the least restrictive means, meaning it wants to take away the least amount of powers from this individual. So that is an ever ongoing battle with the court, because their role is to protect this individual, to protect their rights, right? And you're coming in as a family member trying to take away their rights so that you can act on their behalf. Now, while you're trying to do a moral and ethically good thing, the court's going to say, even if you're doing it appropriately, we still want to restrict the authority we're giving you. So just be aware that that's going to always happen in a conservatorship case. With private documents, it can be different, right? Because if I'm creating my own power of attorney, I can specifically say what powers I want my agent to have and what powers I do not want them to have, right? I have much more say while I'm competent in saying and delegating these tasks, the authorities, the powers, the rights, and any limitation therein. Once I'm deemed incapacitated, right, at that point, it's the court and whoever's filing this petition who are going to be at odds and trying to determine what powers that person should and should not have, okay? So obtaining authority, right? The types of conservatorship. There's numerous of types, kind of briefly go through them. It's not too important as a general conservatorship. Typically what that means is a general conservatorship. I won't even go to that. A limited conservatorship is a little bit easier. You're just seeking authority over the conservatorship of the person, right? I'm only seeking conservatorship over my mom because she has diminished healthcare capacity, right? I'm only looking to make medical and health decisions. I'm not looking to make financial decisions. She has told me that she wants me to be the one who's making these decisions, or she's not able to. I'm the only child who lives in California while she has children outside. I'm the one who's going to be making, being the day-to-day. She wants me, essentially I'm the appropriate person, right? So limited means of the person. It also means limited because I'm only going to get limited powers. General conservatorship usually means much vast, greater powers that the court's going to provide to me. Limited as the name suggests, limited. Probate conservatorship, I won't go through that. Financial conservatorship, that is what we call a conservatorship of the estate, right? So sometimes I file a conservatorship of just the estate. Sometimes I file just a conservatorship of the person. Sometimes I file both, okay? You can do that in the same petition. You can do it at separate times. Again, all done through the court, just seeking to be able to handle someone's finances, right? The difference between the two is a conservatorship of the person. Once you're appointed and powers are given, the court will set biennial, so like basically every 1 to 2 years, they'll set like what's called a order to show cause or a review hearing, just to touch base. They'll have the court investigator reach out to everyone, make sure the conservatorship is still appropriate, and then once they submit their report to the court saying it is, it'll just keep moving on kind of seamlessly. A conservatorship of the state, much more complex. The conservator, so in my example, me over my mother, I would have to file biennial accountings. And these accountings are very complex and they're very detailed. And I have to put forward a ton of information. They have to be drafted by an attorney's office, and they are scrutinized by the court. So I have to file that every 2 years. There's a hearing set, and the court will review it and make sure that is being done appropriately, make sure that I'm managing my finances appropriately, right? Now we have the court involved in determining whether or not I'm actually managing this person's estate appropriately, okay? And sometimes it's a good thing. A lot of times it's not, right? A lot of times we don't want the court involved scrutinizing my every decision, right? Excuse me. Not to mention I have to give notice of this conservatorship to a lot of different parties, potentially family members, potentially the court, potentially the public guardian, the public defender, potentially the regional center, right? You understand that this kind of can get extrapolated. And like I said, when the more cooks that are in the kitchen, the more complex and the more family issues it might result in. Okay. Continued on with obtaining authority, determining who should represent the person, right? This is in a conservatorship or a guardianship or private documents, no matter the circumstance, it's going to be who should represent this person, right? One person can act alone or a partner team can work together, right? Some questions are going to be who can check the mail, who can pay the bills, who can manage the real estate, pay the utilities, right? Pay property taxes, make sure the upkeep and maintenance on the house or on the investment properties, whatever the estate looks like, is being handled, okay? Similarly, handling appointments, right? Managing recovery, making decisions, like that person would, right? Trying to do your best to make the decisions based on your knowledge of this individual, right? What have I talked to about this individual for 30, 40, 50 years, right? What have they said about their healthcare, right? Do they want to be on, when they have an advanced healthcare directive, do they want to be resuscitated? Is there a DNI? Is there a DNR? Is there a DNH? Right? What's it look like when they ultimately do pass away? Do they want to be cremated? Do they want an urn? Do they want to a burial? What does their funeral look like? Right? Is there funeral insurance? Right? These are all discussions that go kind of along with who should represent. Because if I'm having this discussion with my mom for 40 plus years, right, and then she names someone completely different who has no idea, that probably wouldn't be prudent, right? Or if she wants to name that person, she needs to have that discussion with that person or involve that person in communication, right? So this is all just things to think about when making this a determination on who you want to represent, yourself or a family member, should they need, right? And then any dietary needs or restrictions, prescriptions, medical schedules, right? Those are all things that a conservator of the person or a power of attorney for healthcare or advanced healthcare directive agent, right? This would all be decisions that are made involved in those types of scenarios. So again, who should be doing this? For example, I'll use myself again here. My brother is a registered nurse. He's been doing it for over 10 years. He's a travel nurse. He's worked in various states throughout the US. He has much more knowledge with the healthcare system. He has much more knowledge about, he could be able to call an audible if he's in that medical room with my mom and he sees or hears something, the doctor or the nurse or someone else, the CNA or that, anyone else who's involved in that medical assistance, he could hear something and say, oh, you know what, I need to discuss this with my mom. I need to make her aware, or I need to make a decision based on what's going on, right? He's the appropriate person. Now, because I do this type of work, right, I may be the appropriate person to be named as the financial person, right? So this is all a conversation to be had. Sometimes you don't have the scenario that my parents have with an attorney and a nurse, right? Some people don't have that ability. So then you need to find the right person. And sometimes it's not a family member. Sometimes it's a friend. Sometimes it's a more distant relative that's not necessarily a child, right? It could be a grandchild, could be a niece, could be a nephew, right? Someone who you trust to make the decisions and someone who you feel comfortable with having these conversations and communicating with. Okay. Ultimately, you can also hire a fiduciary. You could say, I love my family, but I don't trust any of them to do this. There are professionals who serve as fiduciaries just to do these types of functions and roles, right? Now, the downside is they're more expensive, and you would probably have to go through a process of interviewing a few so that you can get comfortable with it and trust an individual that you would like to move forward with. Okay, continuing on. This is kind of regarding the court process. If I needed a court conservatorship or a court guardianship, we have to get a medical evaluation. That medical evaluation has to be filed with the court. Witness statements. This is going to be a part of the process. The public defender's office is going to be appointed, potentially private counsel, a court investigator, right? They're going to interview a lot of people. It's not just your first degree bloodline, potentially second degree relatives, and anyone else with pertinent information. That could be neighbors, that could be friends, that could be constituents at your church, right? Or any of your other extracurricular activities, people that you're involved with in your life. They're going to be interviewing them, right? If you're at a assisted living facility, they might interview employees that commonly assist you there, the managing facility supervisor, right? They're going to get statements from everybody because they're going to want a complete picture of this person's life and who the appropriate person is, right? And they're going to submit reports to the court with their findings, okay? Filing with the court, right? You have to file numerous documents, not just a petition, but you have to file confidential documents about the conservatee, right? This person themselves. Why do they need it? What kind of care do they need? What diagnosis do they have, right? What medical conditions do they have? What limited restrictions are they able to do physically, financially, mentally, healthcare wise, right? All this information has to be provided. And then similarly, you have to provide it about yourself. If I'm filing a conservatorship for my mother, right, I need to tell the court about myself. What's my arrest history? What's my financial history, right? Do I owe this person money, right? Do I have a conflict of interest? If I owe my mom $400,000 because she fronted me for a down payment on my home and I haven't paid a dime of it, right? Technically, she's a creditor to me, right? And so I would have a conflict of interest if I'm trying to be appointed to manage her affairs, right? It doesn't mean I'm going to do anything nefarious, and it doesn't mean I'm not ultimately going to pay it off. But the court wants to know this, right? These are all things that have to be kind of put forth into the court's purview so that they can survey the entire landscape, right? Because their role is to protect my mom in this instance, okay? Following the legal process, right? There's a lot of things we have to do that we have to file, not only that the state of California provides under the California Probate Code, but the California Court of Rules. Then there are specific county local rules, right? And some of these times these conflict, and we have to follow all of them, right? So it becomes a little bit more complex, a little bit more daunting. And because of that, right, it's going to raise costs because of procedural and administrative requirements, right, that we have to do no matter what, right? Even if you come in and say you don't want to do that, if we're going through the court process, we have to follow their mechanism, right? We don't have any wiggle room. I mean, like I said, legal fees. People will say, well, what's the difference if you're going to do an estate plan for thousands of dollars? And I'll kind of just give you a preface here, right? When you come in with someone, let's say my mom has created an estate plan, right? And she comes in and she's done a power of attorney. She's done an advance healthcare directive, right? She's done what she was supposed to do, okay? And I come in and I say, hey, Larry or Lloyd or James, whoever else is meeting with them. Look, my mom did these documents with your firm or another firm, and I need help and guidance. I'm trying to go to the banks. What do I need to do to go to the banks? What do I need to do to start marshaling the assets, paying the bills, right? It's going to cost money at that time too, right? There are things you're going to have to do. Just because you do private documents does not mean it's going to be cheap or free. There's things that are going to happen, right? But here's the difference. If you end up with a conservatorship, you're going to end up spending that same amount of money plus infinitely more. As we continue, if you come in, right, we do the private documents, yes, there's going to be some initial documents that we have to prepare for you, some advice, some meetings, right? It's going to cost some time and some money. But once you've been able to kind of commandeer all of the assets and you're now able to make the payments and you're doing things, and we've talked about your rights and duties as the acting trustee, as the acting power of attorney, right? We've kind of gone through that process. We are here then kind of in the background. At that point, you're kind of running the show. Should you ever reach out to us, 3 years later, you need some advice. Okay, sure, absolutely, right? We'll definitely help you at that time, but we're not really intricately involved at that point. And if we're not involved at that point, that means we're not billing for our services, which means you're keeping costs down. Conservatorship, right? If it's of the estate, you're mandatorily having to come back to us because we have to keep preparing those biennial accountings, right? And that alone costs thousands of dollars. And people will go, well, yeah, but what if my mom or dad or whoever it is has a house and a couple of bank accounts? Even it doesn't matter if it sometimes people say it's not a complex estate. It will become complex based on the court's mandated formatting of these accountings. It will become complex based on the amount of communication that you're going to have with our office on a go forward basis. If you come in when your mom's 60 and even though they're lacking capacity because of dementia or Alzheimer's or Parkinson's, or whatever the case may be, right? Any neurocognitive degenerative disease, when you come in, we're going to say, hey, even though this person has declining health, they may live 20 to 30 years, right? And you're going to spend thousands and thousands of dollars every year, every 2 years on a go-forward basis, potentially for 10, 20, 30, 40 years, right? So you can extrapolate the attorney's fees, the court costs, and the headache on your end if we have to go through that process. Okay. So kind of just want to touch on that, right? Just give you a general idea, right? Avoiding the conservatorship. Kind of talked about some of the things that they're going to help is having an estate plan, right? Right. I always say have a comprehensive estate plan. That's your trust, power of a will, general assignments, powers of attorney, advance healthcare directives. Sometimes if you're married, I would suggest a separate or community property agreement. And there's a whole host of other documents that go along with that, right? Because we're mainly focusing on diminished health, we're going to really focus on the two most important documents, power of attorney and the advanced healthcare directive, okay? So we're going to first focus on the advanced healthcare directive. You may have heard of this as a power of attorney for healthcare. They're both interchangeable. They're both synonymous. So if you see that somewhere, just know that they are talking about the document that gives your authority for someone to act on your behalf for healthcare and medical decisions. Okay. For anyone 18 years and older, I remember the first law firm I worked for, I would go to high schools and colleges because second that person turns 18, right, their parents no longer have the legal authority to make medical or financial decisions, right, unless that individual allows or authorizes them. So at a minimum, your kids, any adult child should have this document, and they should especially have it if they're going away to college. I have seen numerous times where accidents have happened where the child is out of state, they are brought to the hospital, and the parents are contacted, or the parents contact the hospital, and they won't give the parents any information, right? Or the parents aren't able to make emergency decisions. Okay, so it's imperative Want to hammer that home because it's not something that's discussed quite a bit. At a minimum, even if your child has no assets, power of attorney, events or healthcare directive. Okay. Again, avoids delays in critical care. Exact example I just gave you, right? That child is in an accident, the hospital, the parents contact the hospital, and you don't have the ability, right? Now you have to go file a conservatorship, right, of the person for your adult child, right? And you're going to have to do it on an emergency basis, right? You can't wait that 3 to 6 months for that court hearing. You need that hearing to happen within 24 hours, if not sooner, right? And a lot of times the court can't do it in 24 hours. Even an emergency petition in certain settings, especially for conservatorships and guardianships, will take anywhere between 7 and 14 days. Okay, so now you're delayed even in an emergency setting. So I would say it's even more critical for a situation that arises in that instance, right? Whereas if this person had an advanced healthcare directive that says, I name Mark as my agent to make my healthcare decisions in the event I'm unable to, I give them the advanced healthcare directive and I'm ready to go. Once they get it, I can start making decisions. We can start moving and doing things that are going to protect this individual. So it tells your representative your wishes in different situations, right? It can say, right, if I pass away, I want to be cremated, right? Or it could say, hey, I'm DNH, do not hospitalize, right? As my personal choice, right? Whether it's my just belief in life, whether it's a religious belief, right? I can detail all these things to my agents, right? And now we have a memorialized written document that's showing, hey, this is what I want. This is how I want things to transpire. It avoids disagreements regarding care decisions. Absolutely. If I don't have these documents, what if 3 of my family members, let's say my parents are deceased and I have 4 siblings, right? And all of them have equal rights, technically under California law, to petition to the court to become my agent or conservator for healthcare decisions, right? And I'd say 3 of them want to keep me on life support. And one of them saying, hey, Marcus told me over his 40 years of life that he doesn't want to be kept alive if there's no reasonable ability to bring him back to a standard of living that he was previously, right? Before the induced coma or whatever the case is, right? At that point, you have quite a disagreement. What's going to happen is this is going to play out in court, right? And the court does not want to get involved in this type of decision, right? So doing these things, planning and thinking about these items ahead of time will alleviate a lot of concern, right? Because of those 3 people that don't want to keep me alive, this paper is going to say, yes, it's going to hurt them emotionally. And it's not going to be easy for them to digest, but at least I've put in paper what my wishes and desires are, right? It's very clear here that I've put, hey, please don't keep me alive in these instances, okay? Now, it doesn't avoid them completely because, even though it's on a piece of paper, someone can go, yeah, well, I still want this. But then it's a difference between want and desire versus, what I actually wanted, and told my family members, okay? Dangerous for out-of-dated documents. This is extremely important, probably for powers of attorney. It's not law when you execute a power of attorney or advanced healthcare directive. Once you execute it, it's valid, okay? And it should be valid as long as you don't revoke or update it, correct? However, we have seen numerous times where banks will not accept a power of attorney that is more than 5 years old because they will assume, and this is their legal department, will assume that you've revoked or updated it and named other individuals, right? Now, I could see from their liability perspective why they'd want to do that, but it creates quite a bit of an issue, right? Because we have clients calling us saying, hey, I gave them the power of attorney that was executed in 2011. They're not accepting it. Why, right? And at that time, you're going through frustration, you're going through emotional turmoil, you're trying to assist a family member through their time of need, but you also have your own family, right? You have your own issues, problems going on in your own life. And this is just compounding on it. So it's always good. And I'm going to say this for any type of webinar I do, look at your documents every 3 to 4 years. 1, 2, anytime there's a major life event, birth, death, marriage, divorce, kid turning, a child turning a majority, right? Turning 18, going to college, graduating college, right? Anything that you can think of, going out of country, right? Any major life event, it's always good to just briefly, at least you look at your own documents or come have a meeting with us and we can look at them. And we may go, hey, look, you're in perfect condition based on what's going on, based on what documents say, no changes are necessary, right? We'd rather have that than you not do that and then a problem come up. Okay. Similarly, avoiding the court for the healthcare decisions, we're avoiding the court for estate and finance decisions, right? So that's what's called a durable power of attorney. This is what's giving your agent right? The ability to make financial decisions. When to make changes to yours, right? We kind of talked about that. Whenever there's a life event, a life change, and you can name, this is kind of, if you have a spouse that's passed away on this document, you can name successors. You can say this child, and then if that child's unable, this child, if this child's unable, then this friend, if this friend's unable, then this professional fiduciary, whatever your desire is, whatever your family makeup is, we can kind of, provide the appropriate analysis, the pros and cons, and kind of walk you through that, right? How to get started on yours now, right? We want that, like I said, yesterday was too late. If you don't have one, you need one. There are even, and I never suggest this because I believe it causes more problems than it solves, right? And people will say, hey, I've gone on LegalZoom or I've gone on the state of California website. They provide these template forms. Sure, they're about 2 to 3 pages long. You have no explanation as to what you're truly signing, and they are bare bones. They are minimal, right? You may want to constrict or limit or provide much greater detail and control, right? What's the purpose if you're not really understanding what you're signing, and it's not actually accomplishing what you want, right? So I would highly advise against using the state forms, against using legal documentation without attorney advice about what you are doing, what you are signing, and what your actual goals are, because your goals may not line up with what that document is. When to get a DPA, that's DPA. So if you see that anywhere, it's short for durable power of attorney. Again, yesterday was the time for one. Dangers of outdated document, similar for the advanced healthcare directive, no change in that regard. We always want to be reviewing your documents every 3 to 4 years, like I said, and whenever there's a major life event. Okay, like I said, it could be that your documents were already done appropriately, and even though there's a major life event, it's already taken care of, right? If I have a power of attorney, I'm going out of the country, I review it, I've named my parents, and then I've named my spouse, and then I've named my brother, all in that order. But I put either one of my parents can act alone, right? So we can kind of be very detailed, or I could say they have to act jointly for every decision. Now there are myself and a few of the other attorneys here. Some of the attorneys don't agree. It's really a matter of practice. Co-agents are a whole different conversation that we should have, but I'll touch on it a little bit later. Okay, then leaving a babysitter's note for seamless transition. What this means is, if you're going to name a power of attorney, if you're going to name an advance directive, you're going to have a trust with successor trustees and so on, right? You need to, in most instances, you should be leaving some type of note, whether you're telling them it's in a safe, Excel spreadsheet, on a zip drive, a handwritten note, a typed note with these documents. Hey, these are kind of a general idea of where my assets are. Because let's say you just have a power of attorney, but you don't have any indication of where your assets are, it's going to cause your loved one quite a bit of angst to try to go find everything. Now, meet with us, have this discussion with us. Not everyone's family is the same. Not everyone's situation is the same. Sometimes this isn't even feasible. Sometimes it's feasible, but we may not want to, right? So this is kind of an ongoing discussion that we would have with you during a meeting, okay? Avoiding court, other planning options, create a plan for determining competency in your trust, right? So kind of attached to all of this, we have our trust, right? And in our trust, right, we're going to be funding our trust with most, if not all, of our assets, okay? And what we do is, in our trust, we come up with a competency panel, and it'll say, right, I'm in charge of my trust until my competency panel deems me to be incapacitated for the purposes of my trust, right? Managing my trust assets, right? So it's, for example, it'll say my spouse working in conjunction with my primary care physician, okay? And what essentially that means is primary care physician or an independent physician would issue a letter saying I'm incapacitated for the purposes of my finances. The doctor is making the healthcare decision, right, to deem me incapacitated. And then my competency panel is determining me to be incapacitated for the purposes of the law, right? And we want to bifurcate that. Medical doctors typically do not want to make legal determinations, right? And our individuals who are not medical doctors don't want to be making medical determinations, right? So we're making it very clear and making it easy. Here I put my spouse and the doctor. If my spouse is unable or unwilling, right, then it's these next individuals. And we could do it via majority, via unanimous decision. Just depends on your family, right? If you have 4 kids, they may all get along right now, but they may not all get along and have the same thought process when you are basically incapacitated. So it may be something you want to put where it says majority decision, right? A 3 out of 4 rather than unanimous. Or it could be that you want all to be unanimous because that's your intent or desire, or because it's the most effective manner for your particular case. Okay. Again, this also avoids fighting of a family, avoids the need for court, and protects privacy. This is all done with private documents, right? You come in with private documents. They are disseminated only to individuals that need to be disseminated to, right? Whereas the court goes all the way to the second degree, regardless of the scenario, and brings involved the court public defender's office, potentially the public guardian's office, potentially the court investigator, potentially adult protective or child protective services, the county regional center, court appointed counsel for that individual, right? And so on. Sorry, I'm going to take a little sip of water here. I'm talking very much. Okay, bear with me. Thank you. So yeah, that's going to avoid quite a bit. Now, is that going to avoid fighting completely? No. As you know, everyone's family makeup, like I said, is different. There are going to be disputes no matter what you do, especially when, and I've heard some of the senior attorneys here say, and I like this use, when the referee is no longer refereeing, right? That's where issues come up, right? If everyone's on that playing field and everyone's, kind of going at each other, right? There's no one there to kind of mediate, things get out of hand, right? So these private documents minimize that, right? It doesn't negate it completely. It minimizes it to a certain extent. In some instances, it minimizes it all completely, right? And that's the best case scenario, seamless transition, avoids court, they're private, quicker process, ability to make the decisions much faster, and so on. Right? Some common concerns. Transparency is key, right? Some of the caregiver challenges, physical and emotional care of someone is exhausting. So having these documents in place helps. There is nothing we can do to negate the challenges of taking care of someone else. That is something that we will try to minimize with these documents and try to expedite and help you access and help guide you through it. But it's going to be exhausting. It's going to be stressful. There's going to be anxiety. A whole host of your own personal emotions as you go through this. Resentment, right? If you're the one having to do this and other family members aren't contributing, right? That can bring up a whole host of other issues, right? So we want to try to have this plan in place so that we can minimize this to the extent we can, right? Further, we have the financial burden, right? Increased expenses, utilities, vehicle usage, grocery, hiring help, the power of attorney, and the trust have mechanisms for your ability for cost reimbursement, right? For your ability to access these assets to pay for these medical expenses using trust funds, right? Or using this individual's funds so that you're not coming out of your own pocket. Now, there are instances where there's a brief interim phase where you do come out of pocket, right? Or you haven't met with the attorney or the documents are being drafted in place and there's some minor but right. But the best way, the quickest way to reimburse yourself is to try to minimize the pressure and burden that's going to be placed on you or whoever you're naming. Right. That's a common theme. And when I call it the incapacity administration, always a problem. Mark, this is way more than I thought it was going to be. And a lot of that was communication, right? That you need to communicate to the people that you're naming what their duties are, right? And the more that you can help them understand, at least at a basic foundational level, the easier that transition will be, the less of that burden will be, and the less the physical toll and the emotional toll on the actual agent themselves, right? And again, adjusting day to life for the person representative and other family members, that kind of goes in concert with everything else that I was saying. Managing expectations. Again, not every day is going to be a good day. Communication is key. Transparency is key, right? Being open and honest with yourself, right? Knowing when to reach out for help. Those are all very important, very, very important aspects. So always check in with yourself, make sure that you're doing well, with your own mental health. Especially if you're the one taking care of someone else. A lot of times your effort and your energy and your time goes to that person, and you have to always remind yourself you have your own being, right? If you're religious, you have to deal with your relationship with God. You have your family, you have your friends, your loved ones, your own responsibilities. So you always want to be making sure that you're taking care of yourself from a psychological standpoint. Okay. That's be realistic, be honest with yourself and your family, seek help when needed. Temporary, long-term, that can be help with a licensed professional, that can be help from us, that can be help from family members, right? Whatever it is and whoever it is you need to reach out to help with you with this process. Again, going to alleviate the stress, alleviate the burden, and really kind of help you just on a go-forward basis and make sure you're doing okay. Okay, conclusion here. I know I kind of talked about quite a bit. So before I go through that, my aim in this is really not to overwhelm, and I'm sure a lot of you are overwhelmed. But I just wanted everyone to kind of have a basic understanding. What's the court process? What are the private documents? What are the ramifications of not doing anything, right? What to expect if I do an estate plan, right? Where, what are the costs? What are the expenses? What are the time? Kind of what to expect from that. From what should I be talking about with my loved ones? What should I be talking about with the attorney's office? What should I be talking about with financial advisors and CPAs, right? Just to kind of give you an underlying basic understanding. That way, if you're named as an agent, you're not hit with the flood of, oh my God, what what did I sign up for, right? Also to kind of give you an idea of, okay, I'm making a power of attorney. What responsibilities am I placing on this person? What burden am I placing on this person? And worst case scenario, if I don't do anything, right? If I truly love my loved ones and I don't want to do anything, right? Even if I'm stubborn, it's like, okay, what am I going to put my family ones through when I am incapacitated, right? When I no longer am able to make these decisions, what ramifications, what family struggle, what stress, right? What relationships will potentially be broken because of this. And I can't tell you how many times I see relationships strained so much because there was not a plan in place. So I just want to have you at least hear these things at least one time. You come in, you meet with us, we'll go through it in much greater detail. You're like, oh, I remember Mark talking about this part. I remember him saying that. I remember saying this was an option or not an option. Okay. So that's just, again, aim is not to overwhelm you. Just want you to hear these things, have a general grasp. Hopefully we'll be coming out with some more webinars and some more pamphlets, more information. That way we can continue these topics and maybe even get a little bit more targeted about certain aspects of an incapacity administration. And that way we kind of give, our clients and even the general public just more information to prepare themselves. Okay. How we can help, right? We can establish a plan. We can determine the responsible successors and representatives and provide a plan before it is needed. Always preferred, right? Yesterday is too late. There are so many benefits to getting this done especially when everyone's on board, everyone has a great relationship, right? Everyone's getting along. I have my competency, so I can clearly express my desires of who I want to serve, how I want them to serve, right? What are the limitations, right? All of those things are much more easier to delineate and dictate and put pen to paper, right? That way my family has a clear guideline of what's going to happen when I become incapacitated, okay? Call us, right? We can give you the tools to care for your family. We handle guardianships and conservatorships. If we can avoid them, absolutely, right? We want to absolutely avoid those to the extent we can. And on top of that, right, we can discuss and plan, excuse me, discuss these things while you are alive and well. And I'm just gonna keep hammering home on that. When you have capacity, everyone's on board, and you have a clear picture of what you want, and you have the time to think about what you want, right? You're not being rushed to put things on a piece of paper. You have the time to listen to our advice, give you the options, the pros, cons, positive, negatives, discuss with your family members, right? This just helps for a more fully formed plan. And the more fully formed it is, the better it is, the better chance it has, the higher probability it has at reducing problems in the future, right? Increasing seamless transition, reducing your stress, reducing your anxiety, or reducing your caregivers' stress and anxiety. Okay. Like I said, lastly, review, update, and maintain your estate plan every 3 to 4 years, every major life event. Take a look at it. Even if you don't meet with us, sit down with yourself, your spouse, your kids, your loved ones, whoever you want to sit down with, and take a look at it. Just make sure it correctly reflects your desires. It could be that this person is still a beloved family member, but they moved to, you live in California, they moved to New York. Are they the best person to be making healthcare decisions? Maybe, maybe not, right? With telehealth and technology these days, it's not as difficult to have an out of state, out of country agent, but just based on your circumstance, we'll have to look at that. Okay. So this is just some additional background on our firm. Open since 79. We have 10 full-time attorneys, 2 attorneys of counsel, CPA, over 350 years of combined experience. We have advanced tax degrees. We have certified specialists in probate, estate planning, and trust law. Probate, estate planning, and trust law all encompass conservatorships, guardianships, powers of attorney. Those all fall under the umbrella of estate planning and probate and trust law. We also have a lot of highly trained, highly qualified support staff, paralegals, law clerks, legal assistants, secretaries, marketing, so on. Okay. Diverse staff, diverse skills, and like we talked about, numerous office locations. And as we're meeting today, if you want to meet in person, absolutely, that's fantastic. Always nice to put a face, but we can always do Zoom. telephone call, Zoom, right? Any other the telecommunications. Okay, and this is our contact information, right? So we like I said, call anytime. Feel free to visit our website, send us an email, digital evaluation. Please let us know your feedback. Anything that we can do to help provide more information, be clearer, be concise. Although I would love a positive review, if there's anything that I was doing, I know I was talking fast, but I have to give you so much information, so I apologize for that. But I believe this will be posted to YouTube. So if you need to slow it down, you can do the slow down function on YouTube or play it at your own pace. But anything else that you think that can help us put this information out in a more seamless in a more seamless fashion, or some way an easier or better digestible format, please let us know. I will not take it as an insult. Anytime I can do that to increase my performance, the better I get, the better I can to help you, the better I can transfer this information and the knowledge to you, the better you will be in your own personal circumstances. So before, I know I kind of forgot here the chat before I leave. I'm going to kind of go through here, see if any questions. Looks like one question: can or when can executor take conservatorship without probate court? So it's I don't know if I can answer this question, but I can kind of clarify some topics. So an executor is a person named in your will to manage your financial affairs. People will do a will, but again, you want to trust, because a will has to go through probate. Okay. And a will only comes to fruition when someone passes away, right? A will does not help for someone while they're still living. It does not help for incapacity planning. It's only upon death does that will become valid, right? So an executor typically can't, well, not typically, an executor can't take over a conservatorship. Right. So what would happen is if there is a conservatorship and that person passes away with assets, if they don't have a trust, then you have to then close that conservatorship and open a probate up and go through a probate. So again, a way to negate that is to have a durable power of attorney, so that someone can make so I have a durable power of attorney and names my spouse, right? That means my spouse can manage my finances during my lifetime. But to avoid a probate court, right, I want to have a trust, and I want to fund my assets into the trust to make sure that when I pass away, all of my assets in my trust, my successor trustee can administer the trust outside of the court, right? So there's a couple of key takeaways. One, a will does not help manage anyone's estate during their lifetime. So just know that's not the best way to do that, right? You want a power of attorney and a advance liquidator to do that during life. A trust will help negate probate court at the end. Okay. Okay, and that's all I'll kind of answer for today. Again, I'll kind of leave this page up here. I'll kind of mute myself, leave this up for a couple minutes here. That way you have our contact information. Feel free to reach out if you want to schedule a meeting with one of our estate planning attorneys, or if you have someone, that family members that you want to meet about yourself, or someone who you anticipate will be having declining health or already has declined health, right? We can help you and guide you on the most appropriate mechanism and pathway to accomplish what you are trying to seek. Okay. Otherwise, it's been a pleasure speaking with you this afternoon. Thank you for taking the time out of your busy days to come and meet with us today. We hope you enjoyed it. We hope you got some information out of this. We hope like I said, I know that I overwhelmed everyone with the amount of information, but again, just want to kind of give you some idea and background and information on all this. Okay. So I hope you have a great rest of your day. And the weekend's coming up. I hope you have a great weekend, and hope to see you relatively soon. Okay. All right. You take care. Okay. Bye.